All right, good morning. Welcome back to Daybreak. It's now more than 10 minutes past 7 o'clock. I don't know how to count there. I think it's about 11 minutes. But all the same, I want us to take a look at the state of the judiciary because we know that yesterday Chief Justice David Maraga spoke very passionately. We'll start by looking at the state of the judiciary in as far as the information that we got from Chief Justice. At the Environment and Land Court, there is a 2 years backlog. The caseload the Chief Justice spoke about 16,457 cases that are pending at the court. There are 33 judges that are not able to to hear these matters conclusively. And if a case was filed today, being yesterday or even today, if you have to speak in current matters, then the earliest that it can be heard is in 2022. That's why you're saying that that's a 2-year backlog, according to the Chief Justice. If you look at other courts that also we know the Chief Justice spoke about, this is the Court of Appeal. There are 15 judges, but the caseload as it stands now is 7,315. So for them to hear such kind of matters, it will take about, let me see, 15 divided by 75 should be about 500. It will take 500 cases per judge to hear them conclusively. I don't know whether that's humanly possible and how long that will take. You take a look at another court, that is the Court of Environment and Labor Relations Court. We have 12 judges. The caseload is at 13,197. So these are employment issues, the labor disputes that an employer and the employees would have. They are totaling 13,000. How to hear those with 12 judges is what the Chief Justice does not know. It would take 1,197 on average, 1,000 cases per judge for them to be in a position to manage that caseload. But also you will appreciate that there are certain benches that require more than one judge. So Chief Justice David Maraga said that in July 2019, these are facts that we know, that in July 2019, that is last year, the Judicial Service Commission recommended the appointment of 11 appeal judges. We'll be talking about the names of those judges shortly after now. But on the 13th of August, the Judicial Service Commission recommended another 30 new judges to the President for appointment. These judges, 20 of them were to join the Environment and Land Court, and then 10 of them were to join the Employment and Labor Relations Court. The President declined to appoint them. As we speak now, that has not happened. Then in March 2020, the court faulted the President's delay in appointing these judges. Then the Attorney General, Paul Kihara, indicated that there was going to be an appeal against that ruling that found Uhuru Kenyatta as having faulted the rules. Then these are the stranded nominees. The 11 judges I told you that have been recommended for appointment to the Court of Appeal. Justice Francis Tuyot, currently at the High Court. Justice Helen Omondi, currently at the High Court. And Justice Pauline Nyamoya, also at the High Court, were to be promoted to the Court of Appeal. That has not happened more than 10 months later. Let's take a look at some other judges. Justice Weldon Korir, Justice Musaga Mbogoli, Justice Agri Muchelule. These are all judges of the High Court. They were supposed to be elevated to the Court of Appeal. That has not happened as yet. We take a look at another slide. We talk about Justice Jessie Lesit. You might know her. Justice Mumbi Ngugi, Justice George Odunga. All these were supposed to be elevated to the Court of Appeal. That has not happened. Let's see who else was to join that list. This is Justice Joel Ngugi and Advocate Imana Laibuta. They were supposed also to join the Court of Appeal, but that has not happened. Let's quickly take a look at some of the slides that we have of other stranded nominees that was to join the other courts, especially at the Environment and Land Court. If we have those slides, this is not cooperating, but you can listen to Chief Justice David Maraga when he spoke yesterday about the standoff between the executive and the judiciary. Then shortly after, we look at those other slides that have to do with the other stranded nominees to different courts.
The Constitution does not donate any mandate to the President to perform any other act upon receipt of the names recommended by the chairs, except to appoint them. Both courts categorically held that the refusal by the President to appoint the 41 judges was a grave violation of the Constitution. Having reached that decision, the court in petition number 369 of 2019, consisting of 5 judges, directed the President to appoint those judges within 14 days. The Attorney General, as is now his practice, filed notices of appeal, but he has not done anything to prosecute appeals, if any, from those decisions. Neither has he obtained any stay of execution in either of those cases. The legal position, therefore, is that the President is obliged by the two court-valid orders to appoint the 41 judges within 14 days of the decisions of those two courts.
So obviously the president is out of time. Now, these are the other nominees. Environment Land Court. I will not read, what am I saying? I will not read all the names, but these are the names. You will be in a position to read them, including Boyo Ogutu, Lilian Kimani. Like I said, Environment and Land Court, they were to receive 20 more judges. And then if you can look at the other slide of these nominees, that were also to join the Employment and Land Court, you'll see that it totals to the figure of 20. And then at the Employment and Labor Relations Court, they're supposed to have 10 judges. We'll be giving you those slides shortly. But as we do so, joining us this morning is Honorable Abdikadir Mohammed. He is a former Member of Parliament, but also a constitutional lawyer. Good morning, Honorable Abdikadir. And when you look at... okay, go ahead.
Hi, go ahead, yes.
All right, so when you look at this situation, the president, of course, not appointing these judges, the Chief Justice has said that he has been looking for audience with the president. It hasn't happened. I mean, how does this speak about the situation of the relations between the two arms of government, and what do you think would be the solution out of this stalemate?
Hi, morning. I think the situation is untenable. There is no doubt that the Chief Justice and the President must resolve this issue. You cannot have the two arms of government essentially having a fight in public square. This situation is not the first time it's arising. It arose in 2015 when Justice Mutunga was the Chief Justice then. The conflict, essentially, the root cause of the conflict is the presumption in the President's office that the President has a role in the appointment, in the process and in the substance of the appointment. Now, that's a legal position to take. There's no problem with having a divergent legal position from the judiciary, but you don't get self-help to be the way to prosecute. You don't decide, you have sent me judges, I have not had my say in how they were appointed, therefore I'm not going to do what I'm constitutionally required to do. So I think the President's office is completely out of order in terms of the way it has acted in this matter. The second is, I think the gentleman who really is in the crosshairs here is the Attorney General. The Attorney General is a senior member of the Judicial Service Commission.
Right.
He is the titular head of the bar. He is the President's key advisor on legal, the President and the government's key advisor on legal matters. So really, you cannot have a fight at this level, this untidy, because you're holding the whole country hostage. You are interfering with the lives of 40 Kenyans, people who are accomplished. The 11 judges to the Court of Appeal, 10 of them are current serving High Court judges. The issue about corruption, in my opinion, is key, but in this setup, really, it's a red herring. It's really an excuse to fight a different battle. Because number one, all these gentlemen and ladies were vetted through the Judicial Service process, Judicial Service Commission process. So if anybody, whether it is the Kenya Anti-Corruption Commission or the spy agency or the CID had anything advised to say about these good people, they had ample opportunity at the interview and processing point. Once that has been, once the process moves forward,
right,
after appointment, if you have anything to say against them, there's a process of doing so. That's really not be done. So the presidency has not helped itself in this process. You might have a different view legally, lawfully, but you don't execute it through self-help.
Okay, and of course there are those reports, and this was adduced before the court when the case was still active, saying that the questions of integrity and other personal affairs. So what avenue does the president have if indeed he has such serious evidence? What should he do? Because those people are asking, why go ahead to appoint a judge at a time that it will be very difficult to remove them from the office? of course, also respecting the separation of powers and that Judicial Service Commission is final. So how do we resolve all these matters and all this crisis?
So the system is supposed to work together. These gentlemen and ladies were not picked from the roadside in one dark night. There was an advertisement. There was an interview process. These institutions were written to by the JSC. They were required reports. If they gave reports and the JSC did not think those were substantial, that's where the matter ends. The president or the presidency cannot decide, because we think we have a role in the appointment of judges, we are going to ambush the process and self-help by closing the valve at the point where it reaches us.
Right.
You have a long process of interview and analysis before the nomination. Put your reports there. The JSC has not stopped anybody from, including the members of the public, from sending reports to the JSC. At one time, the JSC used to hold its interviews in an open process. So really, I don't think that is the core of the matter. I think really that is the red herring. Second, if the Attorney General has put the notice of appeal and then decides to let the case go fallow, that tells you really that this is all about delaying and disrupting this process, as opposed to helping us with getting better candidates, so to speak. The 11 judges the 11 nominees to the Court of Appeal, 10 of them are sitting judges. If you really have substantial evidence of malfeasance against any of them, there is a duty on you right now, because they are delivering judgments and operating as we speak now.
Right.
So it's very unfair to them, because you put the allegation out there that one or any of them could be corrupt. Yet you don't come forward with any evidence. It's really very unfair to the judiciary in this sense.
Okay.
Then this is being done in the environment where Parliament is emasculated. So those who feel that this is really the executive ensuring that they now emasculate the third arm of government, those people then get credence to that allegation. Because why, other than getting control of the judiciary, why else would the executive be operating in this form? Okay.
And Honorable Abdikadir, I will get back to that, but first I want us to listen to the President of the Law Society of Kenya who spoke yesterday, that is Nelson Harvey, calling for impeachment of the President, saying that this is a gross violation of the Constitution. Let's listen to that as we engage on this.
We petition the National Assembly and the Senate to initiate proceedings for the impeachment of the President of the Republic of Kenya, because we cannot have somebody who has taken the oath to govern in tandem with the Constitution who fails to perform his duties under the Constitution.
And of course, Honorable Abdikadir, the process of impeaching a president is well defined in law, that it has to come from a member of Parliament, and the National Assembly may petition the House, supported by a third, and of course that process goes all the way to the Senate, and the Senate has the final word, which has to vote by a two-third majority. Do you think this is the route that we should pursue, and do you think the failure to appoint these 41 judges would amount to grounds for impeachment of a president?
Now, first of all, I think it's unfortunate that the Law Society's petition will not go anywhere, because the National Assembly and the Senate, they are long gone. We really don't have a parliament, so to speak. We have the opposition and the government cooperating in parliament, and the result is that parliament as an institution is irrelevant. You see, the presidential system depends on checks and balances, on these institutions checking and balancing each other. Not because any one of them is superior to the other, but because that's the way the system is supposed to work. So when you remove a key check like the legislature, because the legislature in this case is absent, the legislature really should not even be earning any salary. They do zero work except rubber stamp anything the executive says, including who is going to be chair of any of their committees. I mean, imagine the football team deciding who the opponents will be and who the referee will be. How will you lose such a game? So in that sense, irrespective of the merits of the Law Society's position, because the legislature has abdicated, that will not go anywhere.
It will not go anywhere, but do you agree that these are grounds for impeachment?
Now, the president must abide by the Constitution. and not abiding by the Constitution is one of the grounds on which the president can be removed. But other than being a legal issue, the removal of the president is also a political issue, because the president holds that position by virtue of the fact that he was elected to that position. That political process, the political side of the process, requires the other elected arm of government, the legislature, to come in and play its role. It doesn't matter how legitimate the legal side is. Ultimately, it depends on the political side holding the president politically to abiding by the Constitution. Now, the Chief Justice said, you have decided not to abide by court orders. You have breached the Constitution. The Law Society has taken it to the rightful court, which is the court of the legislature. In my respectable opinion, the legislature is long asleep. It has no chance in hell of ever prosecuting or processing that process, because they have abdicated their role as a check to the executive. You require for the Constitution to work properly. You require the legislature to check the president, for the president to abide by court rulings, so that you have the rule of law, not rule by law. The president and the executive recently, for example, gave orders to Kenyans to stay indoors. Those were lawful orders. If the public reviews, what would they do? Why then would you not obey court orders yourself? The assumption then is that orders and laws are for other people to obey, not for the government. That is a classic failure of the rule of law. The law must hold everybody accountable, and everybody must be equal before the law.
Okay, all right. I want us to take a look at what the Chief Justice spoke about last week after the President gazetted an executive order that revises the executive order of 2018. And in that order, the President appeared to reorganize, or rather to declare how the government is organized. And the Chief Justice said that the judiciary is neither a ministry nor a government department which can be organized by an executive order. This was his response to that gazettement. Then let's take a look at something else that he spoke about. He said that the executive order cannot restructure or assign functions to the Judicial Service Commission or its chairman. Of course, the CJ is the chairman of the Judicial Service Commission. He also said that I want to believe that this was how do I read that? I want to believe that this was an inadvertent error, that the office of the president will promptly issue a correction. And lastly, he said that the executive order has no legal effect, as the Constitution is clear about the creation of the judiciary and the Judicial Service Commission and the authority and functions. And Honorable Abdikadir, so we've been seeing these back and forth between the executive and the courts for quite some time. We never used to see fights between the Chief Justice and the President before then. What have we come to, and how do we ensure that, yes, the arms of government remain independent, they respect one another, but they're able to also collaborate on how to move the country forward?
So first, on the specific issue of the executive order, I think the Chief Justice and many in the country misunderstood the role or the function of the executive order. It's really not amending the Constitution or any laws. It's really the president or the executive saying how they will run their part of the government, but also how they will link with other parts of the government. So that if it is, and I think the Attorney General clarified this position. So this, I think, is really a misunderstanding of the court order and what it means. Every time a new president comes in, or every time there's a major restructuring in the executive arm, which the executive has a right to do, an executive order called Executive Order number 1 usually is given at the beginning of the term, and if it has a different number during the process. So really, this is a misunderstanding as opposed to a substantial rift. But it also speaks to the environment. It speaks to the environment between these arms of government. And that's where the problem is, because the constitutions are documents. They are given life by people and by behavior and by culture. So you should really have a culture of constitutionalism as opposed to just the dry black letter of the Constitution. So it speaks to senior men misbehaving, essentially. You can't really have the president and the Chief Justice addressing each other through the media or spots like this. It really speaks to where we are as a country. And the Chief Justice, to his credit, says he sought an appointment with the president and didn't get that appointment. So while substantially or substantively there was really nothing in my opinion, bad with the executive order. The fact that it goes to this length, any misunderstanding. See, when you have diabetes and you have a small scratch, you get a wound because your body is sick. Because our body politic is sick, every little issue becomes a mini crisis.
Right. And as we conclude, Engineer Lazaro Kanyambok says that we shall revisit. This is a statement after the landmark petition rulings is haunting the judiciary. I believe this was after the presidential election petition. President Kenyatta should be a father figure to the nation. So I don't know how you respond to that. But also, the Chief Justice has less than 1 year in office because he should retire sometimes early next year. And his successor will come to an institution that has seen the kind of beating that has occurred. So moving forward, how do we inspire confidence in the current occupier of that office, but also for the future of the offices of the Chief Justice and the offices of the Office of the President?
It's really the people who hold those offices and how we as a country hold our institutions. The executive, there's no doubt that the executive has really pushed very hard against the judiciary, whether it's because of the famous we shall revisit statement or any other. The judiciary's budget has not increased since 2012. If anything, it has decreased. Every other arm of government's budget has increased substantially since then. The judiciary, as you can see, the appointments to senior officers have been curtailed. So throughout, if you look at the history of the institutional relationship, the executive has been very nasty to the judiciary. What the reason is, I am not very sure. But the point is, really, you cannot have a government with two arms of government. You cannot have a government that does not have, we cannot have the state as constitutionally set up operate without the judiciary. And you demean the entire setup every time you demean one arm of the government. And the judiciary, unfortunately, cannot defend itself. Even the CJ having to read a statement is really a long way from the normal path of the judiciary. So I think it really behoves on the president to be the head of state. The function the president is doing as the appointing authority and as the person swearing them in is really more a function of head of state as opposed to head of government. So the president as head of state, it behoves him, even where he thinks he has been wrong, even where he thinks that process was not proper, for him to be the one following the right process. It does not help when the president then decides, I am going to go to the market and operate like any other operator in the market. If you are a king and you come to the market, you can't ask why you were hit by a tomato.
Okay, all right. Of course, you have advised the president previously. Now, this is my final question. So, based on what is happening, do you think the president is getting the wrong counsel, or is he just not listening to the counsel?
Well, in view of the fact that I did a bit of that before, I think it's not appropriate for me to say what is or what is not. What we have a right to do is look at what is before us and comment. What is before us is that 41 judges were nominated and recommended to the president. The Constitution says the president shall then appoint. The president has failed to appoint them. There was a court case, and the court said, go ahead and appoint them. The president has not appealed. He just put in a notice of appeal. As we speak now, the president is on the wrong.
Okay, all right. Thank you so much, Honorable Abdikadir Mohammed, for speaking to us on that matter of Chief Justice David Maraga's frustrations to speak about what is happening at the courts. And I wish you well, and thank you for your